morning, everyone. You may be seated. Okay, these are case numbers 21 CR 451 and 21 CR 1607, State of Ohio versus Adam Coy. Counsel, please, in your appearance for the record.
Thank you, Your Honor. Paula Sawyers and Seth Gilbert on behalf of the state of Ohio.
Good morning, Your Honor. May it please the court, I am Mark Collins, 006-1207.
And I'm Caitlin Stevens, 0095589.
Both of us on behalf of Mr. Coy, Your Honor.
All right, thank you. Okay, this matter is before the court today on the defense motion for a new trial. Are there any preliminary matters that we need to deal with before moving forward?
I believe, Your Honor, I can probably speak for both sides that we've been working very closely with the prosecution. And I believe today, per agreement, we're going to just have oral arguments on the motions and the affidavits. I believe that there is a new affidavit that was provided to us yesterday from Mr. Pearson, basically restating what was in their motion. Ms. Sawyers wanted to make sure it was in an affidavit form. We also provided them yesterday, I believe, with a notarized affidavit from Mr. Borden, the same one, but just notarized because we had, when we had spoke earlier in the week, we indicated we would try to get that. So in lieu of that, Your Honor, I think I touched base with the court after speaking with Ms. Amlin that it would just be kind of oral arguments today, a couple of exhibits that I don't think there's going to be any issues with stipulating to or their admissibility. One being the email that was turned over from that situation, as well as some of the court documents. I believe Ms. Sawyers also was going to supplement their argument with some information from an expert report that you had initially as well, all the expert reports as well.
That's correct, Your Honor.
Okay. If there are no then preliminary matters, then argument on behalf of the defendant.
Thank you, Your Honor.
May I have the screen, Your Honor, for the computer?
Yes.
Thank you.
Give me a sec.
Well, I didn't have the screen, so, but I tested it.
Are you connected to your table?
I am, Your Honor.
Okay.
May I proceed?
You may.
We just lost it.
We lost it, Judge. I apologize.
Okay.
We are back. May it please the court, Ms. Sawyers, Mr. Gilbert, Mr. Collins, and Mr. Coy. Your Honor, we're here today requesting that this court grant a new trial for our client, Adam Coy. And the reason, as the court is aware, as outlined in both of our briefs, is due to a Brady violation here committed by the state of Ohio. Now, the court is well aware that a Brady violation occurs when the government fails to disclose evidence that is materially favorable to the accused. The court is aware that this Brady duty extends to not only exculpatory evidence, but also impeachment evidence. Through Brady and its progeny, the Supreme Court of the United States and lower courts have decided that the individual prosecutor is responsible, has a duty to learn of any favorable evidence to the others acting on behalf of the government. Meaning, Judge, that the individual prosecuting attorney assigned to the case has a duty to learn of exculpatory and impeachment evidence. But not just the prosecuting attorney, Your Honor, assigned to the case. That Brady duty extends to second chair, as well as co-counsel and the police department. So what Brady boils down to, Judge, in order for the court to find that a Brady violation occurred, there's 3 separate elements. The first is that evidence must be favorably material in the form of either impeachment or exculpatory. The second is that that evidence must have been withheld from the state, withheld by the state from the defendant. The defense need not prove willful or inadvertent withholding, only that the evidence was in fact withheld. And the third component of a Brady violation, Your Honor, is that the defendant was prejudiced. Your Honor, we submit that all 3 components of the Brady violation here have been met and that a new trial should be granted. So the cornerstone, Your Honor, and the guidepost of a Brady analysis is one of materiality. And as the court is aware, evidence qualifies as material when there is any reasonable probability that it could have affected the judgment of the jury. Not that it would have, but that it could have. And that is what Chief Justice Roberts held in the Supreme Court decision of Weary versus Cate. And what's important, Your Honor, to understand is that reasonable probability, the Supreme Court of the United States held that the adjective before the noun of probability, modifying the word of probability, reasonable, is important. And it's important because when determining whether or not evidence is in fact material, the question is not whether the jury would have reached a different verdict, but rather, in the absence of this type of evidence, did the defendant receive a fair trial? That was stated in the United States Supreme Court case of Kiles v. Whitley. We would submit, Your Honor, that in the absence of this evidence, the evidence that the state withheld, Adam Coy did not receive a fair trial at the end of 2024. And so what is this evidence that we're talking about, Judge, that the state did in fact withhold? Well, it comes in the form of an affidavit. An affidavit submitted to the court, to defense counsel, and to the state of Ohio by the man named Jamie Borden. Jamie Borden is not only an expert in use of force analysis, but is also an expert in video analysis. He's a certified video analyst. And in this affidavit, he states that he provided an opinion to First Chair Prosecuting Attorney Pearson. That opinion was based on materials that Prosecuting Attorney Pearson provided to him, as well as publicly available materials. That opinion was such that Adam Coy's conduct appeared to be in response to a perceived deadly threat on December 22nd of 2020. That's the evidence that we're talking about here, Judge. Now, what else does that affidavit state? Well, in number 9, in conjunction with the first page, Your Honor, that opinion states that when he was discussing his opinion with Prosecuting Attorney Pearson, it was made clear to Mr. Borden that Prosecuting Attorney Pearson was in search of an opinion that coincided with the state's theory. When Mr. Borden made clear that his opinion, absent some additional evidence, was going to remain unchanged, Prosecuting Attorney Pearson went ahead and terminated that relationship. Jamie Borden states, I made it clear that my expert analysis, opinions, conclusions would not be amended regardless of whether I was retained by the state of Ohio or the defense. And so what we have here, Your Honor, is an opinion that was provided to the first chair prosecutor, an initial opinion based on a surface review, based on materials that was provided by the state of Ohio that stated Adam Coy's conduct appeared to be in response to a perceived deadly threat on December 22nd of 2020. So that is what the evidence showed. That's the evidence that we're discussing that was in fact withheld. Now, the state of Ohio, through the court's order, overturned an email from Mr. Pearson. After the court granted our motion to quash in part, this is what was produced by the state of Ohio. And the date of this email, Judge, is important. And I'll get to why the date of this email is in fact important. But what does this email reveal, Judge? That he not only talked to Jamie Borden and obtained an opinion, but he interviewed a number of potential experts. Now, Mr. Collins and I don't have the benefit of reviewing their most recent email exchange because that part was not turned over to the defense. Only this email that was sent to Mr. Gilbert, who's here in court today, that stated, hey, we interviewed a number of potential experts, landed on Professor Stoughton, and this was our most recent email exchange. Now, why, Judge, is this evidence material? To remind the court of the standard of material evidence, the court must ask itself, in the absence of this evidence, did Adam Coy receive a fair trial? And we would submit no, Your Honor, for two reasons. The first is because this evidence would have impeached the testimony of Professor Stoughton. This evidence would have impeached the state of Ohio's entire theory. But also, Your Honor, this evidence would have offered a new defense theory to the defendant for which he was deprived. With respect to impeachment, Your Honor, and materiality, during the state's opening statement, the state of Ohio, Ms. Amlin, emphasized the importance of the experts.
The state then has an opportunity to refute Officer Coy's use of deadly force was reasonable or justified. In order to do that, the state expects to call an expert witness, Seth Stoughton, to testify regarding national police practices, and the state expects that that expert will opine that Adam Coy did not act within those practices.
So, the court heard Ms. Amlin say that the state's expert is going to opine that Adam Coy did not act within those practices, the nationally recognized practices. You have that, Your Honor, in contrast to what Jamie Borden provided the state of Ohio, that Adam Coy's conduct appeared to be in response to a perceived deadly threat on December 22nd of 2020. The state also goes on to say that how this expert is going to testify about him not being a threat to Mr. Coy. And if I could, Your Honor, I'm not sure what needs to be switched over for the audio.
I'm not sure either.
Okay.
Can you hear it okay, Your Honor?
I can hear it.
Okay, thank you, Judge.
At the end of this case, the state of Ohio will ask you to find that Officer Coy's use of force was not reasonable, that Andre Hill followed the commands of Officer Coy, that Andre Hill was not a threat to Officer Coy or
And so that was the theme that the state of Ohio presented throughout its case in chief, that Andre Hill was not a threat to Adam Coy, that was the opinion that Professor Stoughton provided and gave to the jury. But what was not put in front of the jury, and because the defendant did not know, was this opinion that Jamie Borden, in direct conflict with the statement and opinion by Professor Stoughton, that Adam Coy's conduct appeared to be in response to a perceived deadly threat on December 22nd, 2020. And that was the theme, Your Honor, that followed throughout the state's case in chief. If the court will recall, and it's in the record, Judge, Professor Stoughton argued with Mr. Collins about, I don't remember. I don't remember when I was retained. I don't remember when you sent the material or when the materials were sent to me. I don't remember when I submitted a report. And perhaps Professor Stoughton did not remember and did not have that knowledge. But the state of Ohio had that knowledge. And the state of Ohio had that knowledge because it was the state who sent over that information, and we have that information now, Your Honor, in the form of an email. Throughout closing arguments, Your Honor, the government relied heavily upon the video slowed the video down, played the video, told the jury to rely on your own eyes, when in fact, it was in possession of an opinion by an expert in video analysis that stated Adam Coy's conduct appeared to be in response to a perceived deadly threat on December 22nd of 2020. And so, of course, Your Honor, the defense would have used this information to attack Professor Stoughton in the fact that he was not the state's first choice. We would have used this information to show inconsistencies between the two differing opinions that the state of Ohio had in its possession, that there were no threat indicators versus that Andre Hill presented a perceived deadly threat on December 22nd of 2020. The defense would have used this information, had we been armed with this information, to attack the state's entire theory. We would have been able to argue, but more importantly, show, Judge, that the state started with a premise and it worked backwards, that it shopped until one opinion stuck. We would have used it to attack the prosecutor's theory, and that the prosecution made it known what exactly was expected from the expert pursuant to Mr. Borden's affidavit. And when said expert adhered to his professional standards and did not conform to what the prosecuting attorney wanted, the prosecutor terminated that working relationship. And that's all in Mr. Borden's affidavit, Your Honor. We would have been able to show that the state of Ohio rejected alternative opinions that did not fit its narrative. And so, Your Honor, there exists that a reasonable probability that could have undermined the confidence of the verdict here. The jury might have found that the unimpeached testimony of Seth Stoughton was sufficient to convict Adam Coy. However, Your Honor, the confidence of this verdict would have not been the same and cannot survive a recap of the suppressed evidence and its significance to the prosecution. The defense would have raised and attacked the thoroughness of Stoughton's opinion, but also the state's theory, Judge. There's evidence now, Your Honor, that invites a new defense theory. The whole entire state's theory was that Andre Hill complied, versus an opinion by use of force analyst in an expert in video analysis, that in fact Andre Hill presented a perceived deadly threat. This would not only, Judge, bolster the value of additional impeachment material, but also it would have been used to attack the government's shoddy investigation and expert decision-making and analysis of what it ultimately decided to put in front of the jury. But the jury heard none of this, Judge. The second prong of the Brady analysis is, did the state withhold evidence? This is what was received by Mr. Collins and myself on March 17th, 2021. And again, Judge, I told you that the date was important of the email, and this is why. So when you click here to that hyperlink, this is what is shown. It's the discovery cover sheet by the Ohio Attorney General at the time, Dave Yost, who prosecuting attorney Pearson was acting in front of. And it lists out line by line everything that the state is supposed to overturn to us. On number 3, you will see potentially exculpatory evidence. Because we're not talking about actual exculpatory evidence here. We're talking potentially exculpatory evidence. And what is listed there is none known at this time. Again, Your Honor, this was provided to us on March 17th of 2021. But what also is important about this document is that in the certificate of service, Your Honor, the certificate of service that was provided by prosecuting attorney Pearson stated that this document was electronically served to us on March the 9th, 2021. So while this may be a clerical error, what we do know, Judge, is that prosecuting attorney Pearson was in fact working at this document on March the 9th, 2021. He inputted March 9th of 2021 in this certificate of service when he had this information, when he had the information by Jamie Borden. Now the prosecution, Ms. Sawyers, will submit an affidavit to you by prosecuting attorney Pearson, which confirms this, that prior to March the 9th of 2021, he had obtained this information. He spoke with Jamie Borden. Now, he disputes exactly what was said by Jamie Borden. However, we know that Jamie Borden submitted an affidavit and told the court what was said during that conversation, during that exchange of an opinion. And that was on March 9th of 2021. And on that same day, he edited a document. A document was provided to us 8 days after the fact that stated potentially exculpatory evidence, none was known at this time. Remarkably, Your Honor, the state of Ohio does not dispute the fact that they withheld this evidence from us, because they did. The third element, Your Honor, of a Brady violation is whether or not the defendant, Adam Coy, suffered prejudice. Your Honor, we were precluded from asking any questions that were impeaching to Professor Stoughton on the basis of an opinion that the government provided, that the government was provided. We were precluded, Your Honor, from our experts from opining as to the different expert opinion by Jamie Borden that was given to the state of Ohio. We were precluded from pointing out inconsistencies between two state witnesses, and we were precluded from calling an entire witness on our side. Your Honor, this is legitimately the same as an eyewitness here in the case. Pretend for a second, Your Honor, that roles were reversed here. That Adam Coy is not the defendant sitting in that chair, but rather that Adam Coy was an actor on behalf of the government. He is an officer who is acting on behalf of the government who does not overturn to the prosecuting attorney an eyewitness account of what happened. This court would not hesitate to hold that a Brady violation occurred, and Mr. Collins and I would be here arguing the same exact thing. As a police officer, he had a duty to overturn that evidence so that whoever's sitting in this chair could properly and adequately defend himself. As a police officer who happens to be a defendant judge, he too deserves this protection. This case is no different than if we were talking about any type of eyewitness testimony here that was withheld by the state of Ohio. The government is under a constitutional obligation to turn over all witness accounts, whether they support the prosecutor's theory or not. This is a fundamental guarantee, Your Honor, of due process, a constitutional right that was embedded by our forefathers to ensure that defendants like Adam Coy do in fact receive a fair trial. The fact of the matter is, Judge, eyewitnesses, like expert witnesses, are key sources of factual interpretation and credibility during a trial. Their accounts can affirm, contradict, or complicate the narrative as pushed by the state of Ohio. And this is why, Judge, every opinion, whether it be a lay witness opinion about who did what, where, or an expert opinion as to the analysis of what occurred, whether it be favorable to the prosecutor, unfavorable to the prosecutor, or ambiguous, this is why every opinion, lay or expert, must be provided to the defense. Consider this, Your Honor, the rule that an expert opinion must be provided to defense counsel in advance. Here in this state, it must be provided 21 days in advance of trial. Why? Because the law and the courts and the rules committee that promulgated that rule recognize that these opinions have the power to sway juries and must be subject to rigorous scrutiny through cross-examination and through discovery. Adam Coy was deprived that opportunity to discover this opinion because the state of Ohio withheld it. Adam Coy, Your Honor, was deprived of the opportunity to cross-examine witnesses about this opinion by Jamie Borden that was provided to the government. An expert's credibility, perception, and biases, Judge, are all fertile grounds for cross-examination. And just as we would never tolerate the government suppressing eyewitness testimony, eyewitness accounts in a whodunit case where identity is an issue, we must not tolerate the same, as can be said with an expert witness here in this case. when the court is well aware that this case rises and falls upon expert witness testimony. It is analogous to an eyewitness testimony, an eyewitness account, an eyewitness to be interviewed being withheld by the state of Ohio. We must not permit, Your Honor, the government to cherry pick which opinions, which information it turns over. We must not permit the government to only provide defendants with opinions that fit their narrative. We must not allow the government, while only providing opinions that support their narrative, to bury the other opinions of those that which do not support their narrative. And that's exactly what happened here, Your Honor. To allow the government to cherry pick is a distortion of the supposed justice-seeking function by the prosecuting attorney's office. Cherry picking that which fits their narrative renders this entire process, Your Honor, a process at which the court has worked tirelessly to uphold, but it renders this entire process unreliable and unjust, therefore undermining the confidence that our client received a fair trial in 2024. Now, the state of Ohio's argument in its memo contra doesn't argue that it didn't withhold the evidence, seemingly agrees that it did not provide us with this opinion. In its memo contra, they're not arguing materiality, that even without this evidence that the defendant received a fair trial, but in its memo contra, Judge, they're saying, hey, it's not Brady because it's cumulative. However, Your Honor, we would submit that this evidence is not cumulative, that there are different methodologies that all of the experts used. In fact, Your Honor, it's the same exact reason why the court permitted us to call 2 expert witnesses to begin with during our case in chief. The court didn't buy the government's cumulative argument then, and the court should not buy the cumulative argument now. Anything less, Judge, than full disclosure is a constitutional violation that undermines the trial in this courtroom and requires redress. That redress, Your Honor, ought to be given by way of new trial. This court should send a clear message that it will not tolerate the constitutional violation of withholding evidence so that a police officer, a veteran of the United States military, does not receive a fair trial. If due process is to mean anything, Your Honor, it must equally apply to all, whether this defendant is a police officer or not, especially when the government, with all its power and all its resources, cross the line. We're asking, Your Honor, that this court grant Adam Coy's motion for a new trial. Justice demands nothing less. Thank you, Judge.
Hold on one second, Ms. Steve. I have a few questions.
Thank you, Your Honor.
Okay. Based upon the affidavit that was provided by Jamie Borden, he indicated on the affidavit, after I provided Mr. Pearson with my expert opinion based on a surface review of the incident, and I think he further went on to say that there's additional information that he had not reviewed. So based upon the affidavit that was provided, would he have qualified as an expert witness?
We believe, Your Honor, that he would have qualified as an expert witness. And
Not, again, having done a surface review and not having received the level of documentation that all the other experts reviewed and then used to opine.
If I may, Your Honor, the answer to that is yes, because in there he says, depending upon what's sent to me, testimonial and other things, my opinion's not going to change unless there's something crazy in there, unless there's something totally out of left field.
But that's I guess that's part of my question, because he's saying, I did a surface review, and based upon that surface review, this is my opinion. Absent some additional information coming in, which after I've reviewed that may change my opinion after I've had a chance to review everything.
Correct, Your Honor. And so the key point in that affidavit is he said, I was about to write my report. That's when Mr. Pearson told him no. When you write the report, Your Honor, in every single expert report that we've ever had in use of force cases, it then says, this is subject to an amendment depending on new information that I get or information that may affect my opinion. And that's the case, Your Honor. And so to be clear, Your Honor, I think that for the public and the courts, when the Brady doesn't apply to us. I think if you go back to Mr. Scanlon's testimony and Mr. Davis's testimony, Your Honor, in there, both of them were asked, have we ever referred cases to you that you've turned down? Each of them walked through the process, Your Honor, where they said, yes, I normally do a surface review. I give my opinion as to whether I can work on the case, and then they pay me and I start the report process. I said, Mr. Scanlon, have I asked you to get an opinion from you on those based on a service review? He said, yes. And if sometimes have they been against what I wanted? He said, yes. So I did not work for you in that situation. That happens every single time, Your Honor, in these use of force cases across the country. Professor Stoughton said to the same thing. So yes, they're giving an expert opinion, Your Honor, when they give a surface review. And now, from the defense, if we got that from Jim Scanlon, which we did, I have on other cases, I don't have to turn that over. But the prosecution under the rules in Ohio, they have to turn that over. And that's the bottom line here, Your Honor. It happens all the time. So in that situation, Your Honor, Mr. Borden was ready to write a report and ready to put his opinion, professional opinion, on paper. Now, the government argues in their memorandum of contra and stuff that they weren't asking for an opinion.
I'm going to stop you for a second
Okay.
because you're getting far afield of the question
Okay.
that I'm trying to understand in my head. If the state had called Stoughton to had called Borden to testify, and Borden gets on the witness stand and says, I took a surface review of the information. Here's my opinion. Then on cross-examination, you ask, okay, well, did you review this? Did you review this? Did you review this? Did you review this? And if the answer is no, okay, then you're going to argue that his opinion should be thrown out. Let's say his opinion was supportive of the state. I did a surface review. Based upon that surface review, it's my opinion that the level of force was unreasonable. And he didn't review the level of documentation that everyone sort of outlines in their expert report as to what they reviewed. So if he offered an opinion supportive of the state based upon a cursory review, you wouldn't be arguing that we cannot rely upon his opinion because of the fact that he did not review everything.
Your Honor, they can only review what's provided to them. So yes, they can give an opinion at that time because that's all that was provided to them. He had a conversation with Mr. Pearson.
Okay, I'm
Not
going to stop you
once, but
again,
twice.
okay, because I'm talking about if he were in the courtroom testifying, not trial prep, but if he were in the courtroom testifying, and his testimony was based upon a surface review, excuse me, his opinion was based upon a surface review in which he had not reviewed all of the information.
That goes to the credibility, Your Honor, that the jury determines what to give, but it still goes to the jury. And how you know that the government knows that, Your Honor, is when you look at number 14 of Mr. Pearson's affidavit. I never told Borden that I would not need his service. He remained on my short list to be a secondary expert in the event I thought one was needed. Are you kidding me? He's going to keep a secondary expert that's contrary to his position? That's how you know that he knows he should have turned it over, Your Honor. Because yes, an expert can give an opinion based on their service review because of his video credentials. He's certified in videography. And he can say, that looks like a perceived reasonable response to a deadly threat, a perceived deadly threat. And then it still goes to the jury, Your Honor, absolutely, based on what he was presented.
Furthermore, Your Honor, in order to qualify as an expert pursuant to Rule 702, he's got to lay the foundation that he's got the skills, the knowledge, the education, the expertise. Those are the requirements pursuant to Rule 702, and the threshold, Your Honor, is low, in that as long as he's got that information, and that if he believes that he had sufficient facts and data to come to his opinion, his surface review opinion, and as long as he testifies to the qualifications pursuant to Rule 702 and 703, he absolutely qualifies as an expert here in this state and in this courtroom.
Okay. I'm just considering all the time, all the discussions we had about all the experts and their qualifications and what they reviewed to offer the opinions that they offered. And again, he's not testifying, so I don't know what a surface review is. But a surface review, just at least in lay language to me, means a cursory review.
In the use of force cases, Your Honor, that's the first step in every analysis if you're going to retain an expert, is they have to do a surface review first. It comes down to a monetary thing. You don't want to write the check, Your Honor, before you get the surface review. And that's why I go back to number 14 in the affidavit. I mean, you're never going to use someone that gives you an opposite point of view as your case. So, yeah, so the surface review, Your Honor, is a technical term that's used in use of force cases across the country, Your Honor. And it was testified to Mr. Stoughton, it was testified by Mr. Scanlon, as well as Mr. Davis, Your Honor.
Okay, because in paragraph 7, during our meeting, I provided Mr. Pearson an initial opinion after completing my surface review, video, and publicly released information only.
Now go to the next sentence, Your Honor.
And that opinion was such that without further statement-based evidence, Adam Coy's conduct appeared to be in response to perceived deadly threat.
Every expert is always going to have a qualifier. Even if they write out the report, it will say, however, this can change. And Your Honor, think about how much were in those reports that you didn't allow in, that were caught out. And every judge does that. How much, because the experts don't know what's going to be allowed in, because it's all based on video and hearsay and stuff like that. That's the whole purpose. So think about how many pages that you initially got from each of the 3 experts and how many they actually testified to is very narrow. And basically it comes down to the video. And Detweiler's was in fact available publicly, and that was reviewed. So.
Okay. One of the factors that the court has to consider, as you've already indicated, is the prejudice to the defendant. Now, in a large percentage of cases such as this, there are going to be competing opinions, contrary opinions. I mean, being somewhat facetious, but each side could walk in here with 5, 10, 15 experts opining supportive of their position. So considering the fact that there are going to be contrary opinions in a case like this, and as you indicated, you were allowed to call 2 experts to testify on behalf of the defendant. Where is the prejudice in the sense that you had expert testimony supportive of your position, and obviously the state had an expert supportive of its position? So the fact that an expert was allowed to testify and the fact that you're going to find experts with a contrary position, how does that prejudice?
3 ways that I'll start out with, Your Honor. First, had that been turned over, even as potential Brady material, we would have called Mr. Borden. We'd have talked to him. We would then made an assessment. There would be no more powerful witness in a use of force case than an expert who says, I met with the government. I did a surface review. I reviewed the videos, this, and this, and I gave them an opinion that it was a justified shooting. That when we then called him, and if we called him on direct examination, Your Honor, that would be the most powerful expert ever to testify in the history of use of force cases. Because he met with the state, he sat down with the state, he disagreed with them, and then we would ask him, based on everything that you've seen since, has your opinion changed? And if he said, no, Your Honor, it hasn't, the case would be done at that point in time.
But what if he said his opinion had changed?
Absolutely. Then this is the beauty of the rule for us. We don't have to turn that over, but they do. That's Brady. And that's where people's minds go to. Well, geez, what if he said this? We don't have to use him, Your Honor. Do you see what I'm saying? Under the Brady. Now, the other teams are terms of impeachment, Your Honor. And that's where Ms. Stevens came with a timeline. The timeline of March 9th of that year is most important because that was an email that suggested Mr. Pearson had made his choice of who to use. Okay? So he had had several conversations with Jamie Borden prior to that. He had a meeting with him prior to that. So in that situation, Your Honor, to cross-examine Mr. Stoughton, Professor Stoughton, with regards to you weren't the first pick, and you realize that the first pick that they met with gave them a different opinion. You know who Jamie Borden is, and go through the whole thing. You're not a video expert, are you, Mr. Stoughton? You don't go through that stuff, whereas Mr. Borden is. All in terms of impeachment, Your Honor, up and down the board of Mr. Stoughton. That would have provided us a timeline, Your Honor. You remember, and Ms. Stevens spoke about it, Mr. Stoughton would not give us. He didn't know if he testified to grand jury. He didn't know if he testified by video. He didn't know if he was a grand jury or not. He doesn't even know when he was retained. This would have given us a timeline, Your Honor, to cross-examine him on when, in fact, he was, and we would have then discovered that, in fact, how many more? How many other people did Mr. Pearson talk to, Your Honor, in that email that says, I met with multiple experts? So those things, unfortunately, they have to turn that over if they have conversations with them and an opinion was given. So I don't know, Your Honor, what type of opinion, when in their memorandum contra it says, well, I never got an opinion from him. I wasn't looking for that. I was looking for this. And the issue is, you're not calling Jamie Borden to see if he's going to work for you, to see what's new in Nevada, how are the Raiders doing, or anything like that. You're not. You're calling him to see if he's going to give you an expert opinion that is consistent with your theory of the case. And that's the issue. So all those ways we were prejudiced, Your Honor. It affected our cross-examination of Professor Stout, and it affected our case in chief, because there would be, Mr. Scanlon's wonderful, Mr. Davis is wonderful, but there would be no more powerful person than Jamie Borden, who testified for the state in State v. Mitchell, that to be testifying for the defense now, and after the meeting with the government, that would be the most powerful testimony you could have in a case like this, Your Honor. Because it's not a whodunit. It never is. It's whether or not, objectively reviewed, that is a reasonable use against a perceived deadly threat, Your Honor.
Okay.
Ms. Stevens, did you have anything else?
Okay. All right. Thank you. On behalf of the state.
Thank you, Your Honor. Typically, Your Honor, I would introduce the exhibits at the end of my argument. However, one of them is Mr. Pearson's affidavit. Would you like those first so that
Yes,
you have that?
please.
All right, so State's Exhibit A is the defense expert report of Kevin R. Davis. State's Exhibit B is the defense expert report of James Scanlon. And State's Exhibit C is the affidavit of Anthony Pearson, Your Honor.
All right. Thank you. Thank you.
Mark, Caitlin, do you want a copy of your defense expert's report?
Thank you. And he has them as well. He already had them.
Your Honor, I'm going to start basically where you left off with your questions. The affidavit of Jamie Borden says that he did a surface review, and he talks about one thing the state provided him, which was the public YouTube available video from body-worn camera, and what he terms was publicly available information. We have no idea what that consists of. I would assume it consists of news reports and news articles, because I don't know what else would be publicly available outside of the video. Based upon that, he does what he says is a surface review. Your Honor, I certainly would not title that, anything that comes out of that, an expert opinion. Ms. Stevens says that he adhered to his professional standards. I would disagree with that. I don't know what expert who has professional standards is going to make an expert opinion based upon that limited information, what was publicly available on a video and other public information. In fact, as you yourself pointed out, when you look at what the state's expert consulted to, I'm looking at 5 pages worth of very detailed documentation from the state's expert, Your Honor. For Mr. Davis, he has a page full of detailed information: indictment, BCI initial briefing, which was fairly large, search warrants and residents and vehicles. And Your Honor, I did not provide you with the state's expert report. If you'd like that, I can do so. I just was referencing it for an example. Search warrants, Officer Adam Coy written statement, Officer Adam Coy interview, CPD use of force directive, CPD rule of conduct, and it goes on and on. Everything he consulted to, including the entire prosecutor's package. After that, they offer an expert opinion. A surface review based upon a video and whatever's publicly available, I'm not sure what expert would make an expert opinion based upon that. I'm fairly certain that this court and any other court would not allow such an expert to take a stand based upon only that and issue an expert opinion. And that comes to one of the reasons this is not Brady material, Your Honor. Speculation, State versus Moore, which is a 10th district case, a Brady violation may not rest upon a claim that is purely speculative. That's 2013 Ohio 3365. It is in our memo contra, Your Honor. And the Ohio Supreme Court in State versus Rivas says mere speculation does not meet the accused burden to show that the withheld evidence is material. And that is 2009 Ohio 1354. And again, that is also in our memo contra, Your Honor. We have no idea if Jamie Borden takes the stand today what he would testify to, Your Honor. He is very clear in his affidavit that this was a surface review. That's on paragraph 3, paragraph 6, paragraph 7, paragraph 8. So 4 times he labels it that. In paragraph 9, he says that when I made it clear, he alleges that he made it clear his opinion would be contrary, he said, I would provide an objective expert opinion based on the facts and associated data reflected in a complete and objective investigative review of statements, evidence, transcripts, training, and policy, and not based on a specific opinion to support the prosecution for Adam Coy. He hasn't reviewed any of that in order to offer an expert opinion, Your Honor. He goes on in paragraph 11 to state, I would be willing to testify regarding the contents of this affidavit, as well as my findings and expert opinion based on a thorough investigative analysis and comparison to accepted police practices with respect to the use of deadly force. Nothing in the affidavit indicates that he's reached an objective expert opinion. And in order for an expert to testify as to their opinion, or even a lay witness, it has to be based upon methodology. And that methodology in the use of force includes looking at all available information, as is evident from both defense experts' reports and the state's expert reports in this case, Your Honor, as evident in any trial where an expert opinion is going to testify. They want all available material in order to arrive at an objective expert opinion. Anything that Jamie Borden would testify today is merely speculative, and that does not mean that it is Brady material, certainly does not support a new trial, Your Honor. You will see in Mr. Pearson's affidavit that he disputes that he ever received any type of opinion, lay witness, or expert from Mr. Borden. You will see him say that I provided 2 witnesses that I spoke to with the video, Stoughton and Borden. And then I decided after doing the initial interview, he goes on to say I was looking for areas they've testified in before. Have they testified in civil and criminal? Have they testified for state and defense? Have they researched and written on this subject in a respectable manner? What are their credentials? Are they available? And how do I think they're going to present for a jury? No prosecutor worth their grain of salt is going to call one potential expert witness and say, I'm hiring you. They're going to interview because you want the best expert that you can find based on qualifications to review the material and then issue an objective report. Not unusual to talk to several of them to check on those areas and then arrive at a decision based upon everything. That's what Mr. Pearson did in this case. After interviewing though and talking to some, talking and sending the public video to 2, he arrived at the fact that Stoughton was the better expert for this case, Your Honor, and that is who he chose to come and do a complete, thorough, objective investigation and issue an expert opinion. Anything that Jamie Borden says he did doesn't even come close to qualifying for that. It has to be recognized methodology, has to be a objective expert opinion, and he just doesn't fall under that in this case. If he had gotten everything, we don't know. That would be purely speculative, Your Honor, as far as that goes. Cumulative defense experts, as is shown in the reports, Kevin Davis's report, on page 12, he says the suspect posed an immediate threat to officers or others. Page 13, Officer Coy's perceptions, defendant's use of force is based on his perception. In page 45, it goes on to the references of various factors affecting the officer's perception. He opined that the defendant use of force was within the range of force that reasonably prudent and well-trained officer in the exact same circumstances would have used. Jamie Borden's basic surface review statement was that it appears from the video and what I could find on the news report, he acted within that. Again, that wouldn't even qualify as a layperson's expert opinion or layperson's opinion or an expert opinion, Your Honor. When you look at Scanlon's report, pages 7 through 11, that the defendant had to devote his full attention to the perceived threat of Mr. Hill, page 11, based on the totality of the circumstances and the threat indicators presented by Mr. Hill, Coy's fear of imminent serious injury or death was objectively reasonable. Again, on page 11, it's my opinion that Coy reasonably believed that Mr. Hill was threatening him with the actual firearm and that he, Coy, was in imminent fear for his life and he fired his weapon. Again, that would be, at least based upon what Mr. Borden knows from his very surface review, what he would testify to, and that's cumulative, Your Honor. Certainly is not Brady material as far as it goes. As far as the statements that Stoughton wasn't the state's first choice, again, when you're looking at an expert opinion, you're usually going to call multiple potential experts to see who you're going to retain. Stoughton was the one that was ultimately decided on. Mr. Borden was never retained. He hasn't presented, and the state does not have a contract with him for this case. The state did not pay him. He did not prepare a written report. There's no indication that the state in any way, shape, or form, Mr. Pearson or otherwise, said, Mr. Borden, I want to hire you for this case. It's just not there. That's what it comes down to. As far as defense saying that they would be calling him to the record, Your Honor, in our memo contra to the motion for new trial, the state attached the closing arguments from Mr. Collins in the State versus Mitchell case. He was had a very derogatory opinion of Mr. Borden to the point where I find it very hard to believe that they would, under any circumstances, call Jamie Borden to the stand to testify, because that opinion was based upon the fact that they did not believe he presented with the qualifications to be an expert witness as to the use of force, Your Honor. That's very clear from that closing arguments there. And certainly that would be something that the state would be bringing up should they ever call Jamie Borden to the stand. Your Honor, in order to be Brady material, it must be impeachment. It can be impeachment or credibility. It must be material. It must have a reasonable probability that the result of the trial would be changed. There's nothing here to show this. Again, it's speculative only. We have no idea what an objective expert review by Jamie Borden would produce as far as testimony. Certainly the surface review is not going to be admissible. We have no showing that it's anything but, based upon what he said thus far, cumulative in nature. Anthony Pearson's affidavit directly contradicts everything he says about ever receiving any type of opinion layer expert from Mr. Borden. And there's certainly nothing to show that but for this exclusion, the likelihood of the case would be different, because there's nothing there, Your Honor. You have two defense experts who testified at the trial. You have one expert from the state who testified at the trial. A surface review from Jamie Borden is not going to change the credibility that came with those three experts, Your Honor. Your Honor, if I may have a moment?
You may.
Your Honor, just two more points. This court limited what the expert witness would be allowed to testify to. And that's something that is implicit within Jamie Borden's opinion, that it would be, he acted reasonably, and that's the ultimate issue that the jury was to decide on. Additionally, when you look at Mr. Pearson's affidavit, he had indicated he had still maintained Jamie Borden as a possible second expert up until the Andrew Mitchell trial. And after he saw how he testified at the Andrew Mitchell trial, how defense cross-examined him effectively, closing argument, and attacked his reputation, at that point they excluded him. Mr. Pearson says he excluded him even as a potential expert. You also look within our memo contra, we cite the case law where he's been deemed, as far as Jamie Borden has, his methodology and credentials not to be an appropriate expert in this area. Unless the court has any questions, we'd rest furthermore upon our memo contra.
Well, what is your argument with respect to the defense position that by not receiving this information, they were prejudiced from being able to potentially call Borden as an impeachment witness in their case in chief?
Well, again, Your Honor, anything he would say is purely speculative. as far as it goes. So calling him to the stand to say, I did a surface review based upon the YouTube video and whatever public information he has assessed, we're not quite sure what that is. I'm not sure how that is impeachment material in any way, shape, or form. That would be requiring the state for anybody who comes up to Mr. Pearson in court on the street and say, hey, I watched the YouTube video on the Officer Coy case. I listened to the news article, and I think he was acting in a reasonable way and acted as a police officer should. Then we'd have to disclose every single person who ever said that to us, Your Honor. That is not an expert opinion. That is not even an appropriate and admissible lay witness opinion. This was a surface review based upon what we know for sure is one video. We're not sure what the public information is. Again, Mr. Pearson's affidavit indicates he never received any type of opinion from Mr. Borden. However, if you look at Mr. Borden's affidavit and believe that, it's still not exculpatory or impeachment material because, again, that could be anybody who disagrees with the state's prosecution.
All right. Just give me a second.
Sure.
'Cause obviously, I've not been privy to Mr. Pearson's affidavit until today.
And I apologize, Your Honor,
No.
Yeah.
I'm not saying that. I mean, Borden's affidavit has been available for an extensive period of time. I don't know if you can reconcile what's in Borden's affidavit and Pearson's affidavit, but
Mr. Pearson does agree that,
hold on.
Okay.
Because I have a question. I'm sorry. Just trying to find it. Oh, boy. Let me see. Yeah, okay. No, be a totally unfair question for you. Okay.
I appreciate that, Your Honor.
Yeah. All right, okay, thank you.
Thank you, Your Honor.
All right, response?
Thank you. Briefly, Your Honor, I'll pick up where the prosecution left off, Your Honor. I direct your attention, Your Honor, first to the email, document 1 exhibit, and if I may approach with that, Your Honor.
Yes.
And I also want to give you our exhibit D, Your Honor, with the, D is the notarized.
Okay.
Says potential experts. When the prosecution argues that someone on the street would be walking up and say, hey, I think it's justified, he's not calling people on the street, Your Honor. He's calling well-known, well-established, expensive, experienced, credentialed experts. So anything that they say, it's coming from an expert, Your Honor. With regards to attacking Jamie Borden's credentials, we have never attacked one expert's credentials for their ability to testify in court. We've offered to stipulate because they're all credentialed people. They're all going to be able to testify. Sometimes the standard or the different things, federal and state, of course, we challenge those things, Your Honor. But to say that we did that in closing argument is just not correct, Your Honor. The government keeps talking to you about speculation. Your Honor, even in Mr. Pearson's affidavits, he said he sent him the videos. He sent them. If you Google this case, Coy's video comes up, Ditweiler's video comes up, other things come up. Our client, or Mr. Borden, indicated that he did that, Your Honor. So what more than you hear, gun, gun, gun? What more do you say when our client says gun and then fires a shot? What more when you watch the video and you watch Detweiler's? So that's the surface review. And I direct you, Your Honor, to item number 8, Your Honor, by Jamie Borden on his. Number 8, after I provided Mr. Pearson with my expert opinion based on a surface review of the incident, I was ultimately not retained. Now, he could have stopped there, Your Honor. Did they actually say that Jamie Borden's lying by then saying, as my opinion would not have been helpful to his presentation of the case? That was added for a reason, Your Honor. That has credibility, okay? Item number 14 on Mr. Pearson's, when you go to his, he remained one of my short list as a secondary expert in the event I decided. No person's ever gonna call someone who has a different opinion on their case. So that just doesn't hold water, Your Honor. What also doesn't hold water is the government keeps arguing cumulative, cumulative, cumulative. Your Honor, hypothetically, you have a murder case, right? You have 3 witnesses. 2 witnesses say it was a male white 6'2". One person says the shooter was a male black 5'10", okay? Those are 3 different things. If the male black 5'10" is withheld, it's not cumulative. It's not speculation. It's a contradiction, and it has to be turned over. There's no way to get around that. And there's no way to get around the fact that this was an expert that Mr. Pearson talked to not once, but twice. They have a conversation. Mr. Borden then reviews information. Then they have a second conversation. At that conversation, Mr. Borden says, I gave an expert opinion on a surface review. And I'm ready to write the report. That's also in his affidavit. And that's key, Your Honor, because with regards to the methodology and everything like that, Your Honor, the experts don't ever write a report until they're retained. And then, Your Honor, depending if it's a federal case, it's one standard. Depending on what state they're in, it's another standard. And they don't go over the policies and procedures and practices of the Columbus Police Department at that point in time when they give an initial expert opinion, because they have to then go research those as well. Every state has different, every police force has different. That's why those are the things that are then plugged into their report after. He was ready to write a report, Your Honor, and he was told, your services aren't needed. They can't get around that, Your Honor. And to pick and choose what should be cumulative and what's not, what should be turned over and what's not, they actually have a column that's checked potential Brady material. Nothing's there, Your Honor. So every state, the federal government, there's different standards. That's what goes into the reports that you're then sent, Your Honor. So again, when you look at the two, you can't reconcile the differences. But again, to number 8, after I provided Mr. Pearson with my expert opinion, okay, that's after he reviewed the stuff. He then goes on to say he has no reason to trash Mr. Pearson or to trash the government. They used them in the case right before this. So he has no reason to do that. So why on earth would he make this up, Your Honor? Because it wasn't consistent, and they prejudge it, and that goes exactly to prejudice, and it goes exactly to the unfairness of what may or may not have happened at this trial had we had that information ahead of time. Thank you very much, Your Honor. We rest based on our motions as well as the exhibits, Your Honor, if you had any more questions.
Okay. No additional questions. Now, the email, is that being marked as Defense Exhibit 1?
I believe so, Your Honor, because it was document 1 when it came from the government. They provided it to us in discovery, so however.
Well, the only reason I ask is because the Borden affidavit you have listed as Defense Exhibit D.
Okay. So why don't
And
we
there's not an A, B, or C.
We'll make it an A. How's that?
Okay. So
We didn't want to term it because it was document number 1 in the stuff that was turned over.
okay, but would you mind then if I label the email as Defense Exhibit 1 and the affidavit as Defense Exhibit 2?
Absolutely. And Ms. Stevens is on her way up with a sticker, Your Honor.
Oh, okay. Yes. Just one. No, you already, I just make this. Yes. Okay. And then we have States Exhibits A, B, and C. Looks like the report of Kevin Davis is A, Scanlon, B, and affidavit of Pearson, C.
Correct, Your Honor.
Okay, any objections on any parties with respect to admission of these exhibits, first on behalf of the state?
No objection, Your Honor.
Then on behalf of the defendant.
The only thing I would make for the record, Your Honor, is that the court did keep out a bunch of stuff from the expert reports that they were not allowed to testify to. And I apologize, I don't remember that order off the top of my head, but I know there was things that were carved out and things that were not allowed to be told. So I trust the court will not go into those areas that it said to do that.
No, I think when the court made its ruling with respect to what the experts could opine to, because I know in the reports, they included a lot more information as it related to them, at least making determinations from the court's perspective as to the ultimate issue, which was left up to the jurors to decide. So yes, I think I can compartmentalize what was excluded on behalf of the court. All right. Thank you, everyone, for your time this morning. I will take this under advisement and get a written opinion out.
Thank you, Your Honor.
Thank you.
Thanks, Paul. Thanks, Tom. Appreciate you. Back with you real quick. I'll be right out.
Yeah. You turned everything off? All right, thank you. We're adjourned, ladies and gentlemen. You're free to go.